India's Patent Office had revised its examination guidelines for pharmaceutical patenting. In the revised guideline, there were two major points, including the inclusion of the words therapeutic efficacy while examining the patent applications for a known substance with claims of modification. And the other one was directing the examiners to search for previous data on the patenting of the same claims internationally. There is a clear divide on these 2 points from innovator companies, generic drug manufacturers, and healthcare groups. Any modifications or derivatives of a known substance is qualified for patent grant only when it shows enhanced efficacy. But with the changes made by the courts in the said case, it has very clearly defined what is efficacy, what is enhanced efficacy, which is therapeutic efficacy. But the innovator companies argue that this will be very difficult for them, because at the time of original patent application, therapeutic efficacy cannot be known. At the same time, the generic manufacturers and healthcare groups argue that this is a welcome trend because it can avoid granting of patents for frivolous scientific claims. The other point is the new guidelines instruction for searching patent claims internationally with the generic names. Healthcare groups like Medicine Sans Frontiers argue that this is not possible because many of the applications filed by the innovator companies and research based companies do not mention the generic name in the application, and they normally put very vague descriptions about the research work. So, any search using the generic word or generic name of the pharmaceuticals will not fetch any truthful results. So, it is possible that while searching for the prior details or prior patent claims on the same substance may be misguiding if the examiner use only the generic word of the pharmaceutical substance.